Welcome to this explainer. Today we're diving straight into a truly high-stakes diplomatic standoff between the United States and the International Criminal Court. It is a fascinating, whiplash-inducing look at how global superpowers navigate international law, and honestly, how incredibly fast foreign policy can just flip on a dime. Let's get into it.
To map out this rapid escalation and de-escalation, we're going to break things down into 5 quick stages: sanctioning the ICC, reversing those sanctions, analyzing the nuanced policy shift, looking at the global and legal reactions, and finally, resetting international relations.
So think about this for a second. What actually happens when a global superpower sanctions the prosecutors of an international court? I mean, it sounds like a plot from a political thriller, right? But this played out in real life, on the world stage, over just a single year, and the fallout was absolutely massive. Part 1. Sanctioning the ICC. To really grasp the friction here, we've got to look at the ground reality. The ICC was actively investigating potential war crimes in Afghanistan, and that inquiry included allegations involving U.S. forces. Now, the United States isn't a state party to the ICC, so they fiercely pushed back. The U.S. argument? The court has zero jurisdiction over its personnel without explicit American consent or a UN Security Council referral, period. And the sheer speed of this conflict is pretty astounding. In June 2020, the Trump administration drops Executive Order 13928, authorizing economic sanctions and visa restrictions against ICC employees. By September, those sanctions are live. Then, just a month later, law professors file a lawsuit challenging the order. Come January 2021, a federal judge grants an injunction, and finally, in April 2021, the new Biden administration completely revokes the sanctions. We're talking about going from an aggressive executive order to legal pushback and then a complete 180-degree policy reversal in just 10 months.
Let's zoom in on that September 2020 milestone. The United States officially designated 2 top ICC officials, prosecutor Fatou Bensouda and Fatou Bensouda. And these sanctions were severe. The U.S. government effectively froze their assets and banned them from traveling to the states. They were essentially deploying heavy-hitting financial weapons, the kind normally reserved for rogue states, directly against international prosecutors.
Part 2. Reversing the sanctions.
On April 1, 2021, the landscape completely shifted again. The Biden administration issued Executive Order 14022, which basically acted like a giant undo button. It entirely revoked the previous order and terminated the national emergency declared around the ICC investigation. Just like that, with the stroke of a pen, the State and Treasury Departments lifted the sanctions on Bensouda and Mochachoco.
Part 3. A nuanced policy shift.
Now, what's really fascinating here is the nuance of this reversal. Because make no mistake, this wasn't a sudden change of heart regarding the ICC's authority. Both the Trump and Biden administrations fiercely objected to the ICC asserting jurisdiction over the U.S. They just chose completely different tools to handle it. While the Trump strategy leaned on economic sanctions and strict visa restrictions, the Biden strategy argued those threats were inappropriate. Instead, they pivoted to engaging with stakeholders to push for broader internal reforms within the Rome Statute system.
Secretary of State Antony Blinken perfectly anchored this new approach when he said, and I quote, "Our concerns about these cases would be better addressed through engagement with all stakeholders in the ICC process rather than through the imposition of sanctions." That is a very clear pivot away from financial punishments and back toward traditional diplomatic engagement.
But here's the absolute crucial point you should take away from this. The underlying U.S. objection did not vanish. The new executive order explicitly stated that the U.S. will continue to vigorously protect its personnel from ICC jurisdiction. So the core message remained exactly the same. They just decided to put the financial hammer back in the toolbox.
Part 4. Global and legal reactions. When that hammer was put away, the international consensus was pretty much overwhelming. Major U.S. allies breathed a massive collective sigh of relief and openly welcomed the return to standard diplomacy. The EU praised it, Australia looked forward to constructive engagement, the UK welcomed repeal, Spain called it a big step toward multilateralism, and Norway flat out said it was the right thing to do.
EU High Representative Josep Borrell really hit the nail on the head as to why this matters on a macro level. He called a repeal an important step that underlines the U.S.'s commitment to the international rules-based system. You see, for America's allies, those initial sanctions felt like a direct attack on the international justice system itself, so revoking them? That was viewed as a vital restoration of America's commitment to global legal frameworks.
Human rights groups and legal scholars were also thrilled, of course. But the broader global stakes here are what's really compelling.
Professor Philippe Sands from University College London pointed out that the U.S. sanctions had these, quote, pernicious copycat consequences. Basically, the U.S. actions had given a sort of cover to authoritarian regimes, dangerously inspiring nations like China to slap their own sanctions on lawyers and officials investigating human rights abuses. So removing the U.S. sanctions helped slam the brakes on a really dangerous precedent.
Meanwhile, back at home, this policy reversal quietly tied up some pretty massive legal loose ends. Remember those 4 law professors in the Open Society Justice Initiative who sued the Trump administration? They had been terrified that their work advising the ICC could suddenly subject them to civil or criminal penalties. Well, with the sanctions gone, they agreed to have their case dismissed. Just like that, a remarkably tense chapter of legal uncertainty for American scholars was closed.
Part 5. Resetting International Relations.
By the very end of her term in June, prosecutor Fatou Bensouda, who, let's not forget, had her own assets frozen just months prior, acknowledged the sheer severity of the conflict. She stated the sanctions had crossed a red line, but during a briefing to the UN Security Council, she actually expressed a hopeful desire for a renewed, cooperative relationship. She noted that with the sanctions finally out of the way, the US and the ICC are working on some kind of a reset.
So, as the dust finally settles on this intense diplomatic episode, it leaves us with a pretty big question. How exactly will the U.S. balance its own national sovereignty with international justice mechanisms in the years to come? Because remember, the core friction here remains entirely unresolved, even if the sanctions are gone. This delicate dance of global power and accountability is still very much evolving, and watching those next steps is going to be absolutely fascinating.
Thanks so much for joining me for this explainer.